Thank you very much, fellow Kenyans. I'm Honorable Dr. Babu Owingo, Member of Parliament, Embakasi East constituency. If you like, today you can call me a professor. I'm here ready to dispense knowledge carelessly. So for today, we want to take it a notch higher, where we are going to handle postgraduate students. We are going to handle students from the Kenya School of Law, students who are currently taking their orals, and in November they'll be sitting for their examination. We have 9 units which must be covered. For today, we will cover 1 unit. Then I will communicate on the subsequent dates on when I will cover other units. I want to tell you that whatever we are going to cover today is called criminal litigation. You don't have to be a lawyer. You don't have to train as a lawyer at the Kenya School of Law to be in this class. You need this knowledge for your own survival. I know the day after tomorrow, there is an action, and you need to also defend yourself. You need to know your rights as a person who is going to start some action in the streets. And therefore, I want to take this opportunity to talk to my students, please. I want to take this opportunity to talk to my students at the Kenya School of Law that the Advocates Training Program is simply preparing you to be an advocate. And you need to take things easy, because the elephant in the room was the LLB, the undergraduate degree certificate. The moment you got that, passing this is very, very easy. Just hang on my lips. Let us do it together. I will make it a consultative class. We will communicate. Whatever you don't understand, we will know how to help you. Whatever you feel that I've not covered, you also raise it, so that it is the relationship between the lecturer and the student will be symbiotic, where we both gain. I'm planning to cover almost all the topics in criminal litigation. And therefore, I expect you to have a pen and a book, not a paper, because there will be much that shall be written. So without wasting time, I want to take this opportunity to tell the Almighty God to give us the wisdom and the knowledge that we are almost dispensing, and to ask you all to concentrate in class. Please, if you see your neighbor sleeping, wake them up. Thank you. Welcome to this class. So now, this is not an official program from the Kenya School of Law. I'm doing this because so many of the students from the Kenya School of Law requested me to help them go through these units. So therefore, it is from a request that was given to me by the comrades. So let's proceed. The messages venye zinaingia na make noise. There's interference with the, it's okay. Okay. Criminal litigation. Today is 6th of August 2024. So generally, the criminal justice system is premised on Article 49 and Article 50 of the 2010 Kenyan Constitution, the constitution that was promulgated in 2010. Article 49 talks about the rights of an accused person, and Article 50 talks about the right to fair hearing. So in the criminal justice system, the laws that apply there, number one, we use the Constitution, and we use the Criminal Procedure code. There are institutions that are involved when it comes to the criminal justice system. The first institution, we talk about the police station. The next institution, so we have institutions involved in the criminal justice system. We have a police station. Number two, we have the Office of the Director of Public Prosecution. Number three, we have the Judiciary. Number four, we have prisons. 5, we have approved schools. So these are basically the institutions involved in the criminal justice system. Then, from here, we will proceed to what happens in criminal litigation, and we will go procedurally. So the first step that happens in criminal litigation is the process of making or lodging a complaint by the complainant. So the complainant will complain at the police station. Then the police will carry out investigation. After carrying out investigation, an arrest, so number one, a complaint is registered or lodged at the police station. Then number two, an arrest is made. So the moment there is a complaint made by the complainant, investigation is done by the police, the investigating officer, that is the IO. Then after that, the IO will make arrest. So what is arrest? Arrest is limiting the right to liberty of an individual because of an alleged or an accusation made on the person of the suspect that they have committed an offense in one way or the other. So at the arrest stage, then the question comes that who can make arrest? So who can make arrest? Number one, arrest can be made by a police officer or police officers by the police. Number two, arrest can be made by the magistrates. Number three, arrest can be made by the members of the public or private citizens. Number four, arrest can be made by officers of public institutions such as NEMA or even Kanjo. We all know Kanjo from the county governments. So these are the parties who can make arrest. So the moment a police officer is going to arrest a suspect, at that particular point, a suspect has the rights. So therefore, we go to what we call the rights of a suspect. At this point, we call that person a suspect. Then later on, we will baptize him as an accused person. So what are the rights? We'll just mention them. The rights of a suspect. Number one, right to be told or informed of the reason why he or she has been arrested. Number two, right to legal representation. Number three, right to be admitted on bail or bond, that is police bail or police bond. Number 4, right not to be put together in custody with convicted persons. Number 5, if the person is a child, then there's a right not to be mixed with adults. Then number 6, right to be produced before a competent court of law within 24 hours. Then, not moving from that production within 24 hours, there are exceptions where one can fail to be produced, where the police can fail to produce the suspect to court within 24 hours. The first exception, number 1, if the suspect has been arrested on a day falling before a public holiday. Number 2, if the suspect has been arrested on a weekend or on a Friday, a day falling before a weekend, then that person will not be produced to court. Number 3, by virtue, or rather by the leave of court. By leave of court means that you have been arrested, yes, you must be produced before a competent court of law, yes, but the prosecution or the prosecutor makes a miscellaneous application that you should be held in custody for a given period of time as they still go on with the investigation. So those are some of the exceptions why a person cannot be produced before a competent court of law within 24 hours. So therefore, after a person has been arrested, and there at arrest also, there are offenses. Offenses, because for you to be arrested, you require a warrant of arrest, and there are also those offenses that do not require a warrant of arrest. So offenses that do not require a warrant of arrest are called cognizable or cognizable, depending on where you are born and if you have you have teeth or not. Cognizable offenses. Now, these are offenses which do not require a warrant of arrest. And number 1, such type of offense are breach of peace. You will be arrested without a warrant of arrest if you breach peace. Number 2, a deserter. Deserter means that an officer from the army just leaves work, deserts work. If you desert work, or a police officer. Number 3, we have felony. Number 4, offenses where you are caught in the act. And in law we say in flagrante delicto. Offenses in flagrante delicto. These are offenses where you are caught red-handed in the act. Now, after being arrested, you are still at arrest. You will be taken to the police station. Then at the police station, there's something what we call the ID parade, identification parade. If the complainant who made the complaint against a suspect does not know the suspect well, is not known to the suspect well, then an ID parade will be conducted so that the suspect can be identified positively. Remember, I'm using the word suspect, and that identification does not prejudice, does not mean that you're already guilty. Guilt is proven before a competent court of law. So therefore, at that particular point, an ID parade can be done. So ID parade is the identification parade. The rationale for doing an ID parade is for the suspect to be identified positively. That is the one who allegedly committed a crime. There are procedures involved during the ID parade. The first procedure is that identification parade must never be done by the IO. IO, or the investigating officer, must never conduct the ID parade. Number two, at this particular moment, number two, that the accused person, let me not use the word accused, that the suspect must be notified that there is an ID parade. Suspect must be notified of the ID parade, and the consent of the suspect is very important. Consent is very, very important. Number three, that there must be 8 fillers present to conduct the ID parade. What do I mean by 8 fillers? 8 fillers must be present. Fillers are those individuals that the police will look for. Normally, those individuals with the same physical features. If you have dimples, like Wama dimples, they will look for people with the dimples to conduct the ID parade. So fillers are the people that will be brought together of the same height, same physique, same skin color, so that at least an identification can be done without bias. So 8 fillers must be present. Number 4, that the witnesses must not have known the suspect. Witnesses must not have known the suspect. Now, this was clearly stated in the case of Republic versus Mwago, son of Mana. It's a case that is involving a mother-in-law and a son-in-law. I want you class to read about that case. Republic versus Mwago, son of Mana. Number 5, that the ID parade must not be biased. Biased means that probably the person conducting the ID parade just comes and says that there are witnesses around, the victim is around, and he comes or she comes and says that I think you're the one who did this. Already you are biased. So it must not be biased. Number 6, that the suspect can have or may, shall mandatory, may have a legal representative, legal representation. Now, kwa legal representation or a person to witness the ID parade. Number 7, after identification, then the suspect must be informed on how the whole process took place. Informing the suspect on the whole process. Number 8, after all this is done, there is a form that must be filled called Form P156. You will confirm that. Field. And a report generated. And a report generated that will be used, the report identifying the suspect. This report cannot be used to prejudice the suspect's case. Now, these are some of the reasons. This is the procedure. But there are other reasons that you may know also as class, which are also very relevant to this. There are many other reasons. Then after all this is done, we go to what we call a charge sheet. You will be processed. And you are processed. Now, I've already handled arrest. I've already handled ID parade. So we go to charge sheet as a topic. Huh? Now, in Article 157, as enshrined in the Kenyan Constitution, states clearly that it is the DPP, the office of the DPP, that shall charge, not the police. But in the Kenyan system, it is the police that drafts a charge sheet, takes to the DPP for approval. But the normal procedure, because in KSL, Kenya School of Law, if this is an examinable question, therefore the procedure is very important. Stick to the fact that Article 157 gives the DPP or the office of the DPP the powers to charge. And therefore, the DPP shall decide to charge the suspect. At this particular moment, at the magistrate's court, when you commit other offenses, it's called a charge sheet. If you go to the High Court, it is called information. Information. So you write charge sheet stroke information. Now, at the High Court, what we prepare for information are cases like murder and treason. Other normal cases or other cases, we use a charge sheet. It's only that at the High Court, it's called an information. What are the contents of a charge sheet? Number one, contents of a charge sheet. Number one, the charge sheet must have a count. That is what you see if you see a charge sheet, like a person like myself who has been charged severally. I don't even remember how many cases. I've lost count. There's count one. Then after that, there is the offense that has been committed. Then number three, there is the particulars of the offense. As this is very important because you will be told to draft a charge sheet or information, so you must know about this. Number four, it must be signed by the DPP. Very, very important and urgent. So, the suspect in custody, after charge sheet has been drawn, after the DPP agrees to charge the suspect, the DPP will determine in which jurisdiction. So I'm coming back to the charge sheet. Actually, much of the information about charge sheet, we are done with it. So just drafting it, that's what we will do in another class. But the particulars of the charge sheet are the counts, number one. Number two, the offense. Number three, particulars of the offense. And the signature of the DPP. So that's under the charge sheet. Then we have what we call the jurisdiction of the court. I ought to have started with this slightly earlier before arrest, but let us just finish with it. Number one, and what has made me remember this is about the information and the charge sheet. The High Court, some offenses being done in the prosecuted in the High Court, some in the Magistrates Court. So in jurisdiction, we have what we call the geographical jurisdiction. That if you are arrested in Nairobi, you should be charged in Nairobi. If you are arrested in Mombasa, you should be charged in Mombasa. The idea that the police arrest you in Nairobi and takes you to Kirinyaga the way they did to me, that is complete gibberish and balderdash and nonsensical. So geographical jurisdiction means that where you have been arrested, the nearest court, you should be taken to that court. Number 2, original jurisdiction. And on jurisdiction, we'll handle it in civil litigation, another lesson. Today we are dealing with criminal litigation, original jurisdiction. Now, under original jurisdiction, High Court has an original jurisdiction to deal with cases like murder, treason, and also contempt on the face of it. Then we have the Magistrates Court that can deal with cases like assault, cases like obtaining with false pretense, cases like robbery with violence, robbery, and those other cases. That is original jurisdiction. Then in civil litigation, just to mention, we have pecuniary jurisdiction that involves money, that some cases will be tried in different courts because of the pecuniary jurisdiction, involves money. We have appellate jurisdiction, which is also in the criminal. Appellate jurisdiction. From the word appeal, comes from the word appeal, that the High Court has an appellate jurisdiction, Court of Appeal has an appellate jurisdiction, and even Supreme Court has an appellate jurisdiction to try certain cases of serious public interest. So, very fast, I think I'm done with that. Let's go back to the moment a charge sheet has been approved and that you are going to be charged. Together with that, we have case files. This is a different topic class. Case files. Because the moment the DPP agrees to charge you, then there are files that must be prepared. So number 1, we have a police file, or let's call it prosecution file. Prosecution file. In the police file, prosecution file, which is more or less similar, I want you to master this order. Without this order, you will completely be wrong because we are dealing with procedure. So when this comes in exams, it must follow this order. So this file has subfiles from subfile A. Subfile A. In the subfile A, there is the initial report, which is the OB report. Class, this one you must master. Do not cram, master. Then subfile B, we have the documentary evidence. Documentary evidence. This one contains maps, the scene, what happened at the scene of crime. Then subfile C, we have the expert report. Expert report. Like number 1, we have the doctor's report. Like in my case, there was the ballistic report. Those are expert reports. Ballistic report. Then subfile D, we have what we call the witnesses statements or witness statements. Witness statements. Then subfile E, we have the accused or the suspect's statement. EF. F, we have the, it's called investigation diary. Investigation. Hizi vitu nilifanya kitambo sana. Sasa kama I can remember these things and chew them like yams. Sebuse wewe. Investigation diary. And it must be in this order. If it is not in this order, please, you will get wrong. Even if you get this one wrong, it will be wrong. EFG. G, we have a charge sheet. G, E, F, G, H. H, we have exhibits. G, H, I. I, we have a cover report. I repeat, class, this must be in this order. Do not bring your order. Do not confuse these things because you will get a wrong for free. Then, once we've dealt with that, we have another file called the advocate's file. In the advocate's file, what do we have there? We have a letter of appointment that the client appointed an advocate to do this case. Number 2, we have a charge sheet. This one can be in any particular order. This one you can deal with it like a drunkard. You can stagger with that. Charge sheet. Then number 3, we have the witness statements. Then number 4, we have statement of defense. Then number 5, we have the accused statement. Very important, number 6, we have the bail and bond terms. Bail and bond terms. Very good. This one you can rearrange them in any way, but that's the content. Those are the contents of the advocate's file. Then another interesting file that we have is the court file. Court file is the name of the court. Court of arms. Charge sheet. This one you can also do it in any way. Name of the accused. Now, these are the types of files that we have. So therefore, now the DPP has decided that he will charge you. So what do? You will be presented in court. You will be taken to court. Then in court, there must be a procedure before a charge is read to you, which is called plea taking. So, in court, there's a small procedure, but we always bypass this. But this is what the law says. That number 1, they must check and ascertain that you are of sound mind, and that you can take plea. Number 2, there must be an interpreter. In case you don't understand, in case you don't understand the language of the court, an interpreter must be there to interpret what the charge sheet is talking about. Those are 2. There's a third one, which is escaping me, but if I remember it, I shall come back there. So that is the court procedure. Sound mind, an interpreter, That's okay. So therefore, in court, I'll remember that. I'll tell you shortly. In court, what happens in court? The charge will be read to you. The third one, an advocate or legal representation. That you have legal representation. That's perfect. Then the moment you're in court, the charge will be read to you. Class, I hope you guys are not tired. This thing is very interesting. You can even decide to represent yourself. Gen Zs, you can represent yourself. At this particular time, you don't even need an advocate. But it's very important. We must thank some of our advocates, like the president of the Law Society of Kenya. Huyo mrembo yenyewe ako juu tu sana. So, in court, what happens? A charge will be read to you. This is what we call the plea taking, which is another topic. A charge will be read to you in a language that you best understand. Then you will respond. That response and that whole process is called plea taking. So therefore, we come to what we call the different types of plea. The first one, you can plead normally and say, I'm not guilty. So you say, plea of not guilty. The second one, you say, plea of guilty. The third one, you keep quiet. Keeping quiet is what we call the or keeping mum is something like that. Number 4, there's what we call the diplomatic immunity. Diplomatic immunity. Under diplomatic immunity, you may be a diplomat and you say that, you know, I cannot be charged on this offense because I'm a diplomat. Diplomatic immunity. Number 5, there's a plea of auto foi. This is a French word. If you want to read it as autrefois, auto foi convict. Out of a convict, you can say that I had been convicted over this matter, therefore it should not be brought here. The court had dealt with it. And that is what we call normally as res judicata in law. This brain. Eh? Number 6, you can plead auto foi acquit. That the court had acquitted me on this matter, therefore it must not be tried here. Keeping quiet is also called pleading mum. Pleading mum. See, mama. Mom. Okay. You will. You plead mum. Should be M-U-R. Anyway, M. So those are the types of plea that we know. And therefore, at this point, we are now in court. At this point, we are now in court. So what happens next? Remember, I'm covering topics going by the procedure. So, if you plead not guilty, let me start there. You plead not guilty. It will be registered plea of not guilty. What is the next step that should automatically happen? The court should grant you bail or bond. It is an automatic thing because the Constitution says that you are innocent until proven guilty. But in Kenya, the court will not automatically grant you that. They want your advocate to apply, and application is done orally. An oral application is therefore done for a bail or bond. That brings us to another topic of bail and bond. This is another topic. This is another topic. This topic a lecturer will take with you 2 weeks. I've summarized it in 2 minutes. So I think you can know the difference. Bail and bond. So at the stage of bail and bond, therefore, what is bail? And what are the types of bail that we have? So bail is in form of money. Money that you pay. Money paid to secure release of an accused. Remember now the word accused is coming in. You are an accused now because you are now in court. Accused of committing an offense. Of an accused. But the rationale of bail and bond is so that an accused can attend court. So money paid to secure release of an accused to attend court. Therefore, we come to types of bail. Number one, when you are arrested, the police should always think of the first thing to give you a bail. That type of bail is called a police bail. But because hapa Kenya polisi wengine ni wazuri lakini wengine bore sana, shenzi sana. Call police bail. So some will give you, some will not give you. Because they always say power from above. If you go to above, there's another above. And if you reach that above also says power from above. So I don't know if it is. Anyway, police bail. Number two type of bail is the bail that you ask for in court. When you are in court, it is called bail pending trial. Bail pending trial. Number three type of bail, after you finish that trial process and you lose a case, you are convicted or you are acquitted, you can choose to appeal or the DPP can choose to appeal. That is called bail pending appeal. Number four, you can win that case in the appeal court or lose it. Then you decide that you want to appeal it or the prosecution appeals the conviction or the sentencing or even on a ruling. That appeal is called bail pending second appeal. You are making a second appeal. Then there's another fifth one, which we call the anticipatory bail. Anticipatory bail. You anticipate that you'll be arresting. This is called bail pending arrest. For example, after teaching here, Ruto can decide to send his thugs or rogues to come and arrest me here tomorrow. Then I rush to court. I take anticipatory bail that you should not arrest me. You need to tell me of the reason why you want to arrest me. Because nowadays it's not even arrest, they are abductions. That bail is called bail pending arrest. After being granted, you can the court can decide to tell you to go to the police station to get to know why they wanted to arrest you. But they will not arrest you because there's a bail that you have called an anticipatory bail. At that particular moment, we also talk about bond. Bond is a security in form of a collateral. Collateral. Security in form of a collateral that the court will have, that you issue to the court to secure your freedom. Collateral that an accused produces in court to secure his or her freedom so long as they will attend court, or he or she will attend court. This collateral, the collaterals are in form of a pay slip, can be a pay slip, can be a logbook, and can also be a title deed. The next is now we discuss the types of bond. Number one is police bond. At the police station, you can be given a bail or a bond. So police bond. Number two is personal bond. Personal bond is where the court tells you that, Babu, we trust you. We know you, we trust you. Just go. Or you stand in for yourself. Personal bond. Number three, another type of bond that we have is called bond and surety. Surety. Now, bond and surety, that brings us to this word called surety. Surety is a person, is in form of a person, a living thing, mtu, who has a relationship, a person with a relationship. Person who has a relationship with an accused person. Can be close relationship. To stand in for the accused person. If you fail, if an accused person fails to attend court, that surety, you will be held liable. You will be arrested, you will be called to court, you'll be arrested, you can be arrested and you will be charged. So, is everything okay? Hey, wacha ni kunywe hata chai. Oh, sorry, maji. Class, tunaendelea, tuko sawa? Lazima mpite orals na exams. Thank you. Then, the court should automatically grant you bail or bond, or both. The court can grant you bail or bond or both. Then the prosecution, saa zingine wanakuwa watiaji sana, wanasema we don't want Babu to be released on bail or bond. Therefore, they must convince the court beyond reasonable doubt that there are compelling reasons, and I urge you to read the bail and bond policy class, that there are compelling reasons, and they want to tell court that because of these compelling reasons, we cannot release an accused person to be out on bail or bond. Number one compelling reason, they always say that an accused person is a flight risk. That if we release him on bail, huyu mtu atapotea, hatawahi kuja kotini, and they must prove that utapotea. For example, if you are a Nigerian citizen in Kenya and you've been arrested for committing an offense in Kenya, and they know that you can run away, then they may opt to prosecute you, to finish the trial process while you are in prison so that you don't go back to your country. That is flight risk, that there's a possibility of you running away. But again, that can be cured by the fact that you can be ordered, the court can order you to deposit your passport in court so that you can't take ndege, not unless unataka kuswim to Nigeria. You can't take ndege without that. Number two reason is that you can interfere with witnesses. That you can interfere with witnesses. And this is very possible. You know, one of the candidates of ICC interfered with all witnesses. In fact, interfered and disappeared with witnesses. The main suspect of ICC. Kwa sijui kwa nini alikuwa anatuita criminals, but it's okay. That you can interfere with witnesses. And in the interference with the witnesses, you can also argue that, you know what, you have witness protection. Chukua witnesses, wafungie huko kwa witness protection. Number 3, that antecedents. This can mean that you had been admitted to bail in another case before, you jumped that bail, you did not attend court, and therefore the court is convinced that if you are given another bail in another case, then therefore you will not attend. So antecedents. So the court may deny you on that ground. Number 4, there's what we call the habitual offender. Habitual offender. That, you know, this person has been committing crimes. Amekomiti, tulimwacha, akakomiti, tukamwacha. So this person is a nuisance in the eyes of the DPP. But again, you can rebut that by saying that every case must be treated with its own facts and merits. The fact that I committed an offense before and I've committed an offense now, allegedly, because it has not been proven, then you should not admit me on bail. Why? And this, I will bring you and take you back to your second year LLB. When you are doing your degree, you did the law of evidence. And you did a case of John McCain versus the Attorney General, the case that was prosecuted in the United Kingdom under the doctrine of contemporaneous similar fact evidence. Dispensing knowledge carelessly. Eh? Can you? Eh? Now, the case of contemporaneous similar fact evidence. John and Sarah McCain was a husband and wife. They used to kill children in a bathtub, text them, then buries them in the yard. Wanaenda kotini, wameshikwa, wanaenda kotini, charged, found culpable. Again, wakishatoka prison, they kill another child in a bathtub. Remember, there's a sequence I'm following here. A bathtub, bury in a yard outside their house. Now, there is a day that another person killed a child in a bathtub and buried in the yard. Same way, the police did not ask any question. The police did not get the suspect, but the police went to arrest John McCain and Sarah, the wife. Then upon the arrest, the High Court found them guilty, culpable. But upon appeal, the appeal court let them free and said that the fact that these people have been killing in a bathtub and burying in the same way in the yard does not mean that they are the ones who killed that other child in a bathtub and buried in the yard in the same way. Contemporaneous similar fact evidence. So this one can be rebutted by the fact that every case should be treated with its own facts and merits differently. Then number 5, we talk about own safety, for your own personal security. Personal security. That if we release him on bail or bond, this person is going to be killed. For example, if an accused person commits an offense and the members of the public are looking for this person to lynch him, then he will not be released because he's going to be killed. Number 6, if an accused person is a threat threat to the national security. This means most cases that falls here, and by the way, it was also in my own case, and they were saying the other day when I was arrested last year, when they disappeared with me and took me to Kirinyaga. They abducted me and took me to Kirinyaga. Imagine the prosecutor was saying that I'm a threat to the national security with all the tools of violence that they have. I'm still a threat to the national security. Anyway, tutakutana mbele. But most cases that they use here are cases of terrorism. So those are some of the compelling reasons, among others, that you may also know of. Then after being admitted to bail, the next thing that will take place is what we call the trial process. Trial process. Kesi imeanza. At the trial process, this is another topic. Trial process. At this stage, number one, you go for the pre-trial. Pre-trial meaning that you sit down, you say that, okay, we want to start our case. The prosecution must start proving the case. Then you agree on how the case will go, the time, in some cases, the witnesses that you will use, the exhibit that you shall produce, the evidence that you shall produce. Now that we call the pre-trial. Then after that, the prosecution must prove beyond reasonable doubt. Must prove the case beyond reasonable doubt. Any shadow of doubt, hey, will make the case collapse. So will suffer an injury. Now, the trial process, the first thing that the prosecution must do is what we call the examination in chief. Examination in chief. So class, this we are also killing two birds with one stone. This trial process is also in trial advocacy, that unit, and it's also partly it is also fully in the civil litigation. So examination in chief, where the prosecution will line up their witnesses, will examine, depending on who taught you English in your primary school, will examine the witnesses. After examination, this is the point where the prosecution is proving their case. Prosecution must prove their case here. Then there will be what we call the cross-examination. At cross-examination is at the point where after the prosecution has finished with all the witnesses, not all, sorry, every witness that has been finished with by the prosecution will be cross-examined by the advocate of the accused person. So they will cross-examination. The main purpose of cross-examination is to punch holes on the case of the prosecution, to check on the veracity, mark that word, veracity of the evidence issued during examination in chief by the prosecution witnesses. Then number 4, the prosecution, and this is done by the advocate of the accused person, the cross-examination. Then we will do what we call the re-examination. The main rationale, the main purpose of re-examination is to verify, verification of any issue raised during cross-examination. Then at that particular moment, the prosecution will close their case. After the prosecution closes the case, prosecution close their case. After they close their case, the magistrate or the judge, depending on the nature of the case, will retire to draft a ruling. And that ruling will show whether there is a case to answer or not on prima facie basis. The magistrate or the judge will retire to draft a ruling to show whether there's a case to answer on a prima facie basis, on face value. And a common case in that is a case of Bat versus the Republic. Bat of BHATT versus the Republic. At that particular moment, if the trial court, where we are, says that you have a case to answer as an accused person, then the accused person will be put to defense to defend himself or herself. So after this, the next stage is an accused person is put to defense. Defense, I think, is single F. Right? Right. Will be put to defense. At the defense, now it is the accused person to produce witnesses to defend him or her. Then the defense advocate or the defense advocate will go through the first process, which is called the examination in chief. Then after that, the prosecution will cross-examine. Cross-examination of the witnesses. This is done by the prosecution. Then number 3, the accused person's advocate will re-examine the witnesses. Then the defense will close their case. After the defense has closed their case, the magistrate or the judge will retire to write what we call a judgment. 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 Remember, judgment haina E hapa. Will retire and write what we call a judgment. At this particular point, if the accused person is found guilty, the accused person shall be convicted. If the accused person is found guilty, the accused person shall be convicted. The accused person can choose to appeal the conviction immediately. But even at the ruling, where there was a case to answer, the accused person could also appeal that ruling. If there was no case to answer, the prosecution can also appeal that ruling. If there's a conviction, the accused person can appeal the conviction. If there is no conviction, the prosecution can appeal that decision. Once the accused person is convicted, then the accused person will go through what we call the mitigation. At the mitigation stage, this is where the accused person cries for the court. Analilia court, anasema, you know, like the way Malala was crying in Senate, I have a young family, don't kill me. I have a young family, don't kill me. The way he was crying in Senate. So you can say that you have a young family. You can say you are a first offender. You can say that you can give any reason that you are good or you are a bishop. Okay? After mitigation, at this particular point, when you are convicted, unaingizwa ndani. Ile bail expire at that particular moment. Suppose you are not convicted. If you are acquitted, convicted stroke acquitted, if you are acquitted, utarudishiwa bail and bond. Bond ile security, it was charged. That charge will be lifted, will be discharged. I'll deal with that in conveyancing, where we are charging titles and how to discharge them. and the doctrines and the principles of charges, just to mention, to tell you that we are sure of what we are doing, the doctrine of tacking, the doctrine of priority, and the doctrine of consolidation. Hey. Eh? Now, where am I? Class. So at mitigation level, after crying, but meanwhile umeingizwa ndani, but either way utarudishiwa your cash bail or your bond. Bond will be discharged, cash bail unarudishiwa. There's something which is called sentencing that will be done. Hii sentencing ndo inasemonga unafungwa, koti inakufunga. So what are the reasons why you are being sentenced? Number one reason, sentence is meant to achieve rehabilitation. Rehabilitation. Number two, sentencing is meant to achieve what we call retribution. Hii ni kurehabilitate. So hata saa zingine usiogope kwenda jela nyinyi. Jela is just a rehabilitation center. So usishtuliwe saa zingine umeshikwa hapa ati nitakupeleka jela wewe. Rehabilitation center, and sometimes there's free food, there's free accommodation, you don't pay rent, there's maximum security more than even the president's security. Pia nisiseme tunaweza nyonga huko, acha niwachane na hiyo. So retribution is based on punishment, that you are being punished. Number three, we call reconciliation. Reconciliation. You are reconciled. And number four is restoration, restorative justice, that you are taken to the original position where you were. So, Kenyans, don't just think that punishment is what is justice. Justice can also be restorative justice, where you are taken to, at least to be seen, taken or to be seen, to be taken to where you were before. So it's called the restorative justice, among others that you can mention. Then after the sentencing, now you can choose the appeal process. So the next topic that we are doing is what we call the appeals. These are topics. Easy topics inamalizwanga in 8 months. Ukienda Kenya School of Law ni 8 months. Tunazimaliza within 2 hours. Appeals. So what are the grounds for appeals? Grounds for appeal. Number one ground, that the trial court erred. Sijui kama hiyo erred or add, made a mistake. Okay, the right thing is add. If you come from wacha nisiite huyo mtu. Add, you say add, made a mistake. Number two ground, that the trial court did not follow the right procedure. So if you are an accused person, you appeal and you say that I had some witnesses which were not heard during the trial process, therefore I seek for retrial or revision so that this case should start afresh in the trial court. That is called the procedure. And in law, the Constitution says that procedural technicalities cannot override substantive justice. What we call the oxygen principle. Hey, not carbon dioxide, oxygen principle. Don't say carbon dioxide, class. You will be suffocated. And that, I think, is in Article 159. Article 159 of the Constitution. The next one, that is under Article 159 of the Constitution. The next one is what we call the new evidence. That there is new evidence. That can be a ground. There can be many grounds. You can add other grounds. New evidence. Then what are the possible outcomes of the Court of Appeal? Number one outcome of the Court of Appeal is that the decision can be set aside, the decision can be verified, there can be a revision, you can get a retrial, revision or a retrial, or upheld. A decision can also be upheld, decision of the lower court. So that is on appeals. Then class, now we go to another topic again. So this topic, we call it what? We call it plea agreement. Plea agreement. Miguna will call it plea bargain. Can Miguna do these things? Eh? He's basking in the glory of his ignorance. Eh? Miguna cannot do these things, one. Kwanza, is he an advocate, Kwanza? Plea bargain or plea agreement. What we call what in layman's language, we call the plea bargain. So, the first, now in plea agreement, what is the normal procedure for plea agreement? There's a procedure that it must follow. Number one, it may be initiated by the DPP or an accused person. May be initiated by the DPP or the accused person. Number two, that the agreement must be lodged in court. Lodging, sile lodging nyingine. Lodging of the agreement in court. Number three, that the court must, mandatory, shall not participate in plea agreement. By participate means that I involved at yao wana call the accused and the DPP or the victim or the complainant to agree on something. And number four, that the nature of the case is considered. Nature of the case must be considered. And number five, that the community interest must be considered. Community interest. Community interest must be considered. Community interest. Why? What am I saying by this? That if this person, if we get involved in a plea agreement, if he goes back to the community, of what consequence is he? Positive, negative, of what consequence is he? And that number six, it's at the discretion of the court to either accept a plea agreement or not. The court may or may not agree. It's at the court's discretion. And why the plea agreement? Why the plea agreement? Why plea agreement? Why would an accused person want to be involved in plea agreement? What we call the purpose of the plea agreement. Number one, that the accused person may want his case to be withdrawn. Withdrawal of the case. Number two, that the accused person may want that a bigger charge, the weight of a bigger charge be reduced to a smaller charge. How do I put it? Larger charge, larger or huge charge or bigger charge be reduced or substituted with a smaller one to smaller charge. Reduced or substituted with a smaller charge. And number 3, that an accused person may not want other charges to be incorporated or added to an existing charge. Other charges not to be added to existing charges. Clearly, this is interesting. Plus, you can clearly notice these things we are doing without reference, dispensing knowledge carelessly from the basket of knowledge, from the oracle, and knowledge is flowing from a region of high concentration to a region of, I don't want to say low because these comrades are, their intelligence quotient is at optima. Let's proceed. So that is about plea bargain, among other reasons, or plea agreement. Then the next thing, we're almost finishing class. Just give me another 10, 15 minutes, we'll be done. The next topic is what we call private prosecution. Private prosecution. In private prosecution, what is private prosecution in the first place? This is where the DPP fails to do his work, then a member of the public once goes to court, seeks the leave of court, leave his permission of court, and asks court that, you know what, the DPP has failed to charge this person, therefore I want this person charged and brought in court. So the court may grant leave or may not grant leave. That is under private prosecution. A good example is Koome, the former IG. If anybody wants to prosecute him, can be done. Any person in government, any citizen can be privately prosecuted. So the conditions for private prosecution is that, number 1, an offense must have been committed, or be seen to have been committed. Number 2, that the DPP failed to discharge his duty of charging. And number 3, that you must seek leave of court as a private citizen. Seek leave of court, permission of court to allow you to prosecute by use of a notice of motion. In a notice of motion, if you are using a notice of motion, I'll teach you under civil litigation, where in a notice of motion, parties that we have, it is also here, parties that we have, number 1 is the applicant, and number 2 is the respondent. Then it starts as follows, that take notice that this honorable court shall be moved. Take notice that this honorable court shall be moved on dash day of August 2024. Where are you leaving dash for the court to fill? On dash day of August 2024 at 9 o'clock or soon thereafter, for the advocate for the accused or for the advocate for the applicant to be heard on the following orders. Order number 1. This is the time that you clap, class. Order number 1, that you certify the matter as urgent. Order number 2, I'll get you that when we are doing extradition, where we use also a notice of motion. So I'm coming there, so suspend that just a little. seek leave of court. And number 4, okay, up to there. And number 4, that the decision, now the court may grant leave or not, that the decision of private prosecution is final. You cannot appeal the conviction, neither the sentencing. But in plea bargain, the previous topic that we've just done, you can never appeal on the conviction, but you can appeal on the sentencing. That's very clear. So you cannot appeal on the conviction, neither can you appeal on the sentencing. That is private prosecution. The next one is, we talk about extradition. 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 Unatoa mtu kwa one jurisdiction, one country to another jurisdiction. For example, somebody committed an offense in Uganda or in America and comes and hides in Kenya. So in extradition, the America as a country will ask Kenya. So America is called the requesting country and Kenya is called the extraditing country. To extradite the accused, the suspect, to their jurisdiction so that he can be tried there. Or you stole a chicken in Uganda, and Ugandans, the way they say that they supply us with eggs, they order for your extradition so that you be tried for stealing chicken in Uganda. So Museveni wants you to be taken to Uganda. So in extradition, there are conditions required for extradition process to take place. Condition number 1, that there must be an extradition treaty. An extradition treaty, that between the two countries, an extradition treaty between the two countries, that Kenya and America have a treaty on extradition. There must be. If there is none in one, then it cannot succeed. And number 2, that the case that the accused is going to be tried on, the suspect, must not be a case that is political. Case must not be political in nature. Ruto anaweza sema tipelekeni mtu huko huyu adiliwe nayo in another jurisdiction. Number 3, the case of double criminality. Double criminality. Double criminality means that the case that you are being extradited for exists in the other jurisdiction in America or Uganda. Double criminality, that case exists in another jurisdiction. And number 4, the case of speciality, the rule of speciality. That if you are going to be extradited from Kenya to US to answer on the charges that you committed, the offense, therefore the rule of speciality states clearly that you can only be tried on the same offense that you are arrested for, you are extradited for in Kenya. So if you did robbery with violence, you can only be tried for robbery with violence, not murder. And number 5, that the fact that you've been arrested for extradition should not prejudice your case. The court should not be biased, should not prejudice your case. Should not be used, should not, just that alone, let that country prove its case. Let the prosecution prove their case in that country. Next one, documents used in extradition. Documents. used in extradition. Now we have two types of documents. We have a country, you call it a requesting country, and we have an extraditing country, Now, a requesting country is a country that requests where you committed an offense. The first document they send to an extraditing country, US sending to Kenya, they send a document called a letter of request. Letter of request. They request, we request you to extradite so and so because he committed offense here in the United States of America. Number two, a charge sheet. A charge sheet. Number three, what we call an overseas warrant of arrest. Overseas warrant. Number four, what we call an authentication certificate. Hizi vitu zilikuwa zinafundishwa Teams University kweli? You can't teach these things in Teams University. That's a cyber cafe university. Authentication certificate to authenticate the above documents. Then there's an extraditing country like Kenya telling US that, you know what, Kenya now having received all these documents that will go to the AG, the Attorney General, then the Attorney General will talk to the DPP, then the DPP will proceed to court. And if he proceeds to court, he will request the leave of court to proceed. At that particular moment, he will use a notice of motion. Number two, under certificate of agency, supported by a supporting affidavit. You can add other documents if you know. Now, come back to notice of motion. So this is where I told you that I want us now to see how will the court be approached. The court will be approached by way of a notice of motion by the DPP. And the notice of motion, of course, you write the name of the court. Then after that, you write the parties. Then you write notice of motion. Then you start. Take notice that this honorable court shall be moved on dash day of August 2024 at 9 o'clock in the forenoon or soon thereafter for the applicant, the person applying, for the advocate for the applicant, to be heard on the following orders. Order number one, certify agent. Order number two, you can request the court that a warrant of arrest be issued on the suspect, such that the suspect is arrested and put in custody. Order number three, that the accused person or the suspect deposits his passport in court so that he cannot travel to any other country. And then you proceed by saying which application is premised or based on the following grounds. Ground number one, you state the facts. What did this person do? Person X committed an offense in the United States of America, and this is what happened. This is what he did. Number two, ground number two, that there is an extraditing treaty between the two countries. Number three, that the fact that we are extraditing this person will not be used against him or any other ground that you may deem fit. Then you proceed by saying which application shall be supported by an affidavit. Then you finish, you date it, you finish. Unaipeleka story imeisha hapo. Then you draft a supporting affidavit. That is extradition. That one will come even 20 marks. Where we? Be careful. These things are easy. So class, that is going to be, that is an examination topic. All these are examinable, but that can be very, very common. Question number 1, it can be brought 20 marks. We have 2 more topics. Just be patient. The next topic that we can do is what we call the habeas corpus. Habeas corpus. Habeas corpus application is an application that is made by an applicant through chamber summons. And the reason why it is made is that this person probably was arrested by the police. We don't know where he is, or he's in a police station somewhere. But the IG, the Inspector General of Police, has refused to produce this person in court. So therefore, you do an application for this person to be produced in court, whether dead or alive. It is called habeas corpus. Produce the body. We want the body, dead or alive. So it is done by use of chamber summons. Chamber summons goes in the following way. Number 1, the court, as you draft it, you draft the court in the High Court. Then number 2, the parties involved. Then number 3, you just write chamber summons. Then it goes as follows. Let all parties concerned herein attend this honorable judge. Not honorable court. Honorable judge, because it is in the chambers. Let all parties concerned herein attend the honorable judge on dash day of August 2024 at 9 o'clock or soon thereafter for the applicant, for the advocate for the applicant to be heard on the following orders. Order number 1, certify as agent. Order number 2, that the Inspector General of Police be compelled to produce the suspect, so and so, to court. Which application, you can add other orders. Which application, or if the person is sick, you can give another order, that the IG be compelled to take that applicant, the suspect, to the hospital for treatment. Then you proceed. Which application is based on the following grounds, or premised on the following grounds. Ground number 1, that while the applicant, so and so, was going to meet his girlfriend, he was abducted on his way, or he had finished with his girlfriend and was still abducted on his way home. Second grounds, you just narrate what happened. Then which application is further supported by an affidavit. Then you finish it. That is habeas corpus. Then the next one, the last one, is what we call the judicial review. Judicial. This is the last one, class. So just hang on my lips. Judicial review. Under judicial review, I just want you to know the grounds for judicial review. Judicial review is also done in civil litigation. I'll also talk about it after doing the criminal litigation. I will tell you it is done slightly different in criminal litigation and civil litigation. They are different. So but grounds are the same. So the first ground is impartiality. Impartiality. Chukua dictionary. Second ground is unfairness. Unfairness. Third ground is ultra vires. Ultra vires, acted outside their powers. Next ground is biasness. Next ground is unreasonableness. Unreasonableness. unreasonableness, among other grounds. Then how do you approach the court? Judicial review means that, you know what, the DPP has decided to charge me wrongfully. Maybe ulimnyang'anya girlfriend, anakuchukia, sasa anasema tu wewe, I will deal with you. Analeta tu charge from nowhere else, anakucharge. That is what we call judicial review. Therefore, you move to court, to the High Court, using a petition in criminal litigation, constitutional petition. And you said clearly that I want to review the decision of the DPP, or the DCI decided to investigate you, and they should not investigate you. It is unlawful investigation. You go under judicial review for the judiciary to review in the High Court. Those are the grounds for the judicial review. In civil litigation, in judicial review, you approach it in two ways. Number one, through the leave stage. In the leave stage, you ask the leave of the court. A situation, case in scenario, if you've been wrongfully impeached and you are a governor, because it is involving a quasi-body, a quasi-judicial body, quasi-judicial body, an administrative decision, not a judicial decision. For example, a student has been expelled from the university or suspended from the university, or you've been wrongfully dismissed at work. Those are wrongful dismissal. You go to court, you approach the court, you seek judicial review, and you seek leave of the court. How do you seek leave of the court? Number one, you seek leave of the court by use of chamber summons. Number two, by use of a certificate of urgency, because it is urgent. Number three, a verifying affidavit. And number four, by use of a statutory statement. Then after that, you go to the substantive stage. Substantive stage, where you use a notice of motion and a supporting affidavit. That is civil litigation. Then some of the orders in civil litigation, we have prohibition, order of certiorari, and order of mandamus. Can either compel somebody to do something, or the court can compel somebody to stop something, or quash a decision. That is in civil litigation. I will also teach you that.